Now we are.
All right, so welcome everybody to our new edition of Intellectual Property, Session 8. We've done 7 before. We finished the trade secrets in the first 6. Last week, I introduced patent law, just very broadly, and we talked about the anatomy of a patent, the different sections of it, what a claim is, what are the different types of claiming, the structure of it, etc. So today we're going to start really talking about the law associated with the patents. The slides are, as usual, pinned to the top, and if you'd like to follow along, I will be referring to slide numbers, which is the number of the slide in the order that appears to you. So slide number 1 is the title slide, which we don't have anything to talk about. So before I get into the actual law, I want to say a little bit about what is an invention, because we, in patent law especially, we hear that word all the time. So what is an invention, and who is an inventor? These are legal terms. They have legal definitions, and those legal terms and definitions are somewhat different than what you and I would say invention and an inventor. They have a much more exact definition of it. So we look at the case of Ethicon Inc. versus U.S. Surgical Corp. These two are, both of them are pretty big players in the medical device industry, and so this is clearly a medical device case. This, incidentally, is one of my all-time favorite cases. When it came out, I was already practicing when it came out, and I was very early on in my career, and it was a lot of fun because the good guys win, and they win big. So let's go into it. Slide number 3. The invention is a system for a trocar. And so what's a trocar? Slide number 3 shows pictures of various trocars, and both just on tabletop and in use. So when you're doing laparoscopic surgery, the tool that the surgeon uses is at the end of a metal stick, right? On the picture bottom right, you see the surgeon to the left is holding one of those sticks with their right hand. And so those sticks, they have the tools at the bottom. When they need to change tools, they have to take the stick out, put another one in, or as they're doing the surgery inside the abdomen, they move the stick up and down to basically use the tool. So they have to move the tool. If that stick is going up and down against flesh, against the patient's body, it's going to cause a lot of damage. So as we all know, one of the reasons we do laparoscopic surgery is to minimize damage to the body, so that you guys may have seen it, or you may have gone through it. When you do laparoscopic surgery, at the end, you don't get any stitches, right? They just glue your skin back together with an acrylic glue and send you home. And that kind of after a few days dissolves and disappears, and you just have a little bit of a scar. So why does that work? It's because the surgical scalpel is extremely sharp, And so when it cuts it, there's very, very little damage done outside of the cut. And so they don't have to stitch them together in order to hold them together and make sure the body has enough time and undergoes the process enough to heal the wound. The edges are exactly the same because they cut it, and so the healing will happen very fast. It's basically, as far as your body's concerned, after laparoscopic surgery, as far as your skin is concerned, you just got 3 or 4 paper cuts. That's as far as much damage as you would receive. So in order to minimize this damage to the area of surgery, you basically put a tube in it, and now the stick and everything else moves up and down through the tube and doesn't come into contact with the skin and the muscles, the flesh of the patient. This tube that you put in is called a trocar. I don't know where that name comes from, but that's what it's called. And so, as I've shown, we see in the bottom 2 pictures, we see trocars used during surgery. They almost always use your belly button as one of the holes to go in to minimize the amount of scarring tissues. And then on the right-hand side, you see that white thing that's up there. That's camera and light. And then the other 2 have the surgical instruments that are used. Usually there are 4 holes. One's for camera and light and air, or CO2. They pump the abdomen with CO2, carbon dioxide, so it kind of pumps up. And there now you get a lot of separation between the organs, and you can reach them. And then once the surgery is done, they just kind of they put a needle in you, and the air comes out. So anyway, what was the issue with trocars? This is not the first invention on a trocar. What is the issue here? The issue is that the skin is extremely tough. As far as strength of tissue is concerned, skin is our second strongest tissue, the first one being bones. So skin is extremely tough, and it's very, very hard to break. I mean, you think about how many times you hit things during the day, and things that are sharp, things that are pointy, and they don't penetrate. They you just go out, and there's no blood, no nothing. It's if that was just muscle, every time you would hit the corner of a table, that muscle would tear, and the corner would basically go into the muscle. So skin is extremely tough. So when the surgeon wants to put this trocar in, the surgeon has to initially push extremely hard. I mean, these are relative terms, extremely hard. But then as soon as the point of the trocar clears the dermis, so first you have epidermis, which is on top, then you have dermis right below that. As soon as it clears that, it's going to get adipose tissue. It's going to get fat tissue, right? All the fat under the skin that I carry around my belly, right? That's right under that. And so what is fat? Fat is extremely soft. So if the surgeon is pushing down with the same amount of force, now the surgeon is basically stabbing the patient with a large knife into the abdomen. That is, there's no control over this extremely sharp object that's going into the abdomen and is going to do tissue damage to anything it comes into contact with. So surgeons, those who did laparoscopic surgery, this was a technique that they had to master, in that how much pressure do you put in at first, and then at what point do you lay off the pressure. And so by the time the surgeon became good at this, a lot of patients suffered because they got stabbed by these trocars. So this invention is by a surgeon, an abdominal surgeon, and the trocar of the invention has an electronic system in it that measures the resistance that the tissue is applying to the trocar. And as the surgeon pushes in, the electronics modulate the force that the trocar receives from the surgeon, meaning that the surgeon can apply constant pressure, but the trocar will then change that pressure as it's applied to the tissue. And so initially the trocar applies a lot of tissue, and then it's the electronics that that make the trocar not go further in when the resistance disappears. And so it takes the game, it makes it a lot easier for the patient to do this, for the surgeon to do the surgery using a trocar. Right now, everybody should know that all the trocars that are used have this mechanism or a similar mechanism in them. So we don't have the old trocars anymore where it had no pressure control. All of them do have that. This is the first patent on the first model of this technology. The surgeon did this, filed a patent, and licensed it fully to U.S. Surgical. And Ethicon was basically using this technology, and so Ethicon sued. U.S. Surgical sued Ethicon for patent infringement. When you sue someone, the first process is the pleading stage, which is the plaintiff files the complaint, the defendant files the answer, then the plaintiff files the reply. And then after that, you go into some motions that are argued about collecting evidence, and then you go into discovery. And in discovery, that's when you ask for documents, they give you documents, you depose witnesses, and all that stuff. You basically gather all the facts for the litigation. During discovery, the physician was asked, you have no training in electronics, you have never done anything related to electronics before or since, so how were you able to invent an electronic system of this complexity? And so finally, answer comes out that I had a technician working for me. And it is at that point I can totally see in that room where the deposition is taking place, that the attorneys for U.S. Surgical basically just said, "Oh shit," and attorneys for Ethicon began salivating, because it's at that point that the case is over. Why? Because of what happens in this case, in that they go and find that person and they said, "What did you do?" And he says, "Oh, I kept all of my notebooks for the development of that, because that was a really cool system, and I wanted to have access to all of my experimentals and data and everything that I had, so I kept all of my notebooks. This is what I did." So they go to the doctor and say, "So what are your notebooks?" And he says, "What's a notebook?" And it becomes clear that this technician was more than just a technician. So was he an inventor? Was the technician an inventor or not an inventor? Does the technician have any rights in this patent? So we're going to explore the law of conception, invention, and inventorship. On slide 4, so this is about, we're talking about a joint inventor to figure out whether this technician was a joint inventor. Joint inventor means if you have 2 or more inventors on a patent, they're joint inventors. So conception is the touchstone of inventorship. So when you conceive of an invention, then you have done an invention and you are an inventor. So each inventor must contribute to the conception of the invention. So what is the invention then? The invention is the subject matter covered by the claims of the patent. That is the invention. Remember last time when we talked about the claims, we said that it's not the specification of the patent that determines what your rights are, but it's the claims. That's the one that determines the metes and bounds of the invention. So if the claim is determining the metes and bounds of the invention, everything inside of it is an invention. Everything outside of it is not an invention. Therefore, the claims define what an invention is. So conception of the invention means conception of the subject matter that's in the claims. Coming up with the idea of the stuff that's in the claims. So conception is the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention as it is hereafter to be applied in practice. So what does this mean? It means that you don't have to have made it. You just need to have formed in your mind a definite and permanent idea of the complete and operative invention. So I can draw a molecule on paper, hand that molecule to you and say, this is a decent way of synthesizing this. And I write down a synthetic procedure for that molecule. If I now hand that to one of ordinary skill in the art, meaning someone who knows how to do organic synthesis, and they follow my synthesis procedure and they come up with a compound, then I am the sole inventor there. Why? Because that compound and the manner to make it the idea of that was formed in my mind, and that idea was definite and permanent, meaning that it was definite because I said this compound, and it was permanent because I didn't forget about it the next day. And it was complete and operative. How is it complete and operative? When one of ordinary skill in the art followed my directions, managed to make the invention. Therefore, it was complete and operative. Is that person of ordinary skill in the art an inventor? No, because all they did was followed my guidance towards that. So what is definite and permanent is when any ordinary skill would be, when only ordinary skill would be necessary to reduce the invention to practice without extensive research or experimentation. Because once you start doing extensive research and experimentation, then the initial idea was not complete and operative. You had to figure out how to make it operative through your extensive research and experimentation. So at that point, the person who does the experimentation becomes a co-inventor on the application. So slide 5, the conceived invention must include every feature of the subject matter claimed in the patent. Nevertheless, for the conception of a joint invention, each of the joint inventors need not make the same type or amount of contribution to the invention. So what all of this is saying is that, let's say person A comes up with the idea of alpha humongousaine that treats breast cancer and a whole bunch of different derivatives of alpha humongousaine, and then I come and say, oh, that bromine group that's over there, maybe we can put a methyl group there, and maybe that would work too. And they're like, oh, all right, go make it. And then I do, and it's like, oh yeah, the methyl group worked. And so claim 175 of 175 claims in the patent is directed to the compound with a methyl group in that position. Even though my contribution was just to one part of one claim out of 175, and I had nothing to do with 174 claims of that patent, I am a joint, and I own that patent jointly and severally with all the other inventors, with the person who came up with the 174 and a half of the claims. I have as much rights in the patent as that person does. And so, but that person has to have contributed to the conception. It wasn't just that the supervisor conceived it and then told the person what to do. That person went ahead and did it, and that is not an invention. It's what one of ordinary skill in the art does. So slide 6, one who simply provides the inventor with well-known principles or explains the state of the art is not an inventor. And posit a person of ordinary skill in the art who simply reduced the inventor's idea to practice is not necessarily a joint inventor. And then slide 7, you guys can go read these on your own. I'm just pointing out the very important stuff. Co-inventor need not make a contribution to every claim of a patent. A contribution to one claim is enough. Thus, the critical question for joint conception is who conceived the subject matter of the claims at issue. And trust me, we take this seriously. we ask people who did what. And when they tell you who did what, they say, oh, Bob was just a technician, so where's Bob? He got fired. All right, let's look at Bob's lab notebooks, because that is prime for things, the conclusions that we'll see here in Ethicon v. U.S. Surgical. That is going to happen. So slide A talks about the standard of proof, that it's not just your oral testimony on developing evidence for this is not clear and convincing proof, and so you need to have corroborated evidence, which basically really means lab notebooks or something written contemporaneously with the invention. So what happens in this case? After that deposition, when people figure out, oh yeah, there was another person involved in the development of this, the attorneys go and find that person, and they do a deposition, look through the lab notebooks, and they become convinced that that person is an inventor on the patent. They didn't need to they didn't need to really go through the details of what he had invented. I mean, they do, but at the end, just the conclusion that he was an inventor was enough. So what happens is that two things happens. Is that actually three things. The first thing is that they go to the patent office and they file a petition to correct the inventorship of the patent. They submit clear and convincing evidence that the technician was, in fact, an inventor. The patent office reissues the patent with the corrected inventorship, having both the physician and the technician on the patent. The physician has licensed all of his rights to U.S. Surgical, but the new inventor or the technician has not. So the technician licensed all of his rights to Ethicon. And so now we have two companies that each have a license to the patent. And so U.S. Surgical goes ahead and so the lawsuit goes away, because there's now no issue. They both have licenses. There's no infringement. So now U.S. Surgical basically goes ahead and files additional lawsuits in federal court. If there's a property dispute, 100% of the ownership of the property has on the plaintiff's side has to be present for the suit to go forward. And here, U.S. Surgical had half the ownership of the patent, and the technician had the other half. So the lawsuit was dropped by the court because 100% of the ownership was not present at the plaintiff's table. So the physician here tried to pull a fast one and cut out the the technician from getting any money out of this. And what happened at the end was that the physician lost the entirety of the patent. US Surgical lost the entirety of the patent. And basically, because of the invalidity of this patent, we saw kind of a mass invasion of controlled trocars into the market based on this technology. So, what is an invention? An invention is the subject matter of the claims. How do you invent? You conceive of the subject matter in a way that one of ordinary skill in the art can make and use it. And who's an inventor? And inventors are people who have conceived that subject matter. So with that background, any questions from people on stage? Hi, John. Welcome. Hi, VP.
Sam.
Welcome.
So I haven't heard everything, but I think the upshot of this is that because was this a patent that was on file and somebody was and the dispute was over whether it was a legitimate patent, and then ultimately the patent was thrown out entirely, so that the guy that actually could have been the inventor didn't reap any benefits from it either. Is that right?
So let me correct what I said. So basically, what happened is that the patent issues as a legitimate patent, naming one inventor. And then the inventor kind of sells or licenses to this patent to a big medical device company. That medical device company goes and sues another big medical device company for the infringement of this patent. That the defendant, the accused infringer, figures out there's another inventor here that was not named. And they go ahead and correct the patent by putting that guy's name on the patent. So now that guy is going to give a license to the accused infringer because he is now jointly and severally owner of the patent in its entirety, meaning that both owners have rights to 100% of the patent. And so he can do that. He can license it to somebody else, which they did. So the lawsuit for patent infringement goes away because he has a license, right? Both parties are now have rights to the patent. So now the question is, there can be no injunction for the future. Both companies can now make this because they both have their rights. So now the question is, what about the past infringements, right? Do I get before this change happened and this guy got a license, he was infringing me, and then the court says no. Prior to that, the patent was not enforceable because correct inventorship was not on that. So because the inventorship was incorrect, that patent was not enforceable. So you could not have sued on past infringements. Once the inventorship was corrected, the patent becomes enforceable for future infringements, but Ethicon cannot infringe because Ethicon has a license. Third parties could, but then Ethicon went ahead and the license that they had became non-exclusive, and so the guy went ahead and licensed it to a whole bunch of people. I'm not really sure about the facts of that, but I know a lot more companies besides U.S. Surgical and Ethicon got rights to this patent after this case. Did that answer your question?
Well, I guess I'm still a little confused. So after all of this, the doctor was not a co-inventor at all, right? He was completely off the patent.
No, he was.
Right?
He was a co-inventor.
Oh, okay.
Yeah.
Okay.
So they
and
both
then,
become co-inventors.
Okay. And the other guy worked for the descendants. Is that right?
Well, the other guy first worked for the doctor, and then right before things became hot, the doctor fired him. And so he basically went and did another job. But during litigation, Ethicon figured out, this other guy exists.
Okay, that's right. So, but I guess I don't understand. So now the patent is still there. I get that the original infringement is gone, but the thing doesn't spread like wildfire unless one of the co-inventors starts licensing it to lots of other people, which apparently the original guy didn't do, or something.
The original guy didn't do once this case was done. The technician did, right. And so I don't know. That's the thing. That's the thing. I don't know what happened.
And then, but both of them profited maybe equally or maybe not equally, but in some divided way from the licensing fees.
Yes, they did.
Okay.
Yeah. Yes, Elliot. I ended up being a lawyer by graduating from law school. That's basically the easiest way of becoming a lawyer.
Do you know anybody that takes the law exam without going to law school?
Yes, you can.
I thought it was a cereal box.
No, it's called reading law. You can read law, but if you read law, you can only be admitted to the state where you read law. You can't go to another state. Anyway, so moving right along, if there are no more questions on that topic, if there are, come on up and ask. So let's go to slide number 9. We're gonna now start talking about some actual laws. Patent laws are at Title 35 of the United States Code, starting with Section 101 and the following section. So that sentence, we write it as 35 USC Section 101 et sec. Et sec is short for et sequanum, which means and following in Latin. So you see that et sec quite a bit in legal citations. So 35 USC Section 101 means Title 35 of the United States Code. The Section 10 gives the 5 parts of Title 35. Part 1 is sections 1 through 42. Those are basically how the structure of the USPTO and the kind of administrative structure of the USPTO. There usually is no dispute in those areas. Part 2, patentability of inventions and grant of patents, sections 100 through 212. So that's highlighted, and even if it weren't highlighted, you would know that that's the section we're going to be focusing on because it's on patentability of inventions. Part 3 is patents and protections of patent rights. Those are all the litigation statutes. Part 4, patent cooperation treaty. That's the international practice part that's done at the U.S. Patent Office. And then part 5 is the Hague Agreement for industrial registration of industrial designs. The U.S. is a party to the Hague Agreement, but doesn't register industrial designs, but recognizes registration of industrial design as a priority document for international applications. So that's why there are only 10 code sections under Part 5. So as I said, our focus is going to be on Part 2, on patentability and grant of patents. And on slide 11, we see that really 4 code sections here is where all the disputes are. And I put in section 271, infringement of patents, because that is also the other code section that in practice you run into all the time, right? And anybody who does patent litigation lives and dies by section 271. But the facts of the litigation are all determined or adjudicated under sections 101, 102, 103, and 112. And in the patent office, you basically only deal with those first 4 sections. Some other things here and there come into play, but 99.9% of the time you're in those 4 sections. We're going to start with section 101, and that's going to be the discussion today. I'm hopefully we can finish 101. I think I'll talk about a couple of cases under 101 next time. So slide 12, 35 USC 101, inventions patentable. That's the title of the section. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent, therefore subject to the conditions and requirements of this title. There is a lot in here, and we are going to dissect this sentence, which on the first run may seem sufficiently clear, but this is a statute written by lawyers for lawyers. It's anything but clear. How? Well, first let's go to slide 13. This is the first thing that we learned from section 101, that if you do these things, meaning come up with a new and useful process, machine, manufacture, composition, matter, you don't automatically get a patent. You may get a patent subject to the conditions and requirements of this title. So what does that mean? It means that you have to satisfy section 101 first, and then satisfy the other sections of the code to see whether subject to those sections you can obtain a patent or not. And so as we see on slide 14, this section 101 is called the gatekeeper provision of patent law, because if you don't get past 101, you don't get to any other provisions of patent law. You have to first satisfy this before we can talk about whether your invention is patentable or not. So the inventions that satisfy section 101 are called patent eligible, meaning that they could get a patent. But the inventions that satisfy the other provisions, they are patentable, meaning that they can be patented. So patent eligible is it may be patented, patentable is it can be patented. So those are 2 different terms that they get kind of tossed around haphazardly by lay people, but those of us in the patent law kind of freak out as soon as people mix up patentable and patent eligible. Section 15 is, or slide 15 is for someone who's interested in law and history, especially patent law. That is very interesting. It is the first patent act that the United States passed April 10, 1790. As Shamash pointed out last time, these were all written by Madison. And so James Madison. And so the title was An Act to Promote the Progress of Useful Arts. That is, as we recall from last time, that is from the Constitution in order to promote the progress of sciences and useful arts. So this is the useful arts part. The first thing is that you, at the time in 1790, you petitioned to Secretary of State, Secretary of War, and the Attorney General. These three at the time formed what was called the Committee of the Arts. And one Saturday every month, the three of them would get together and review all the patent applications and would recommend the patent to be issued to the president, and then the president would have signed the patent. So initially, the patent examiners were those three department secretaries acting as the Committee of the Arts. So that's the green or teal sentence. The yellow one, it says, hath invented or discovered any useful art, manufacture, engine, machine, or device, or any improvement therein, not before known or used. So we can see how close this language is to the language that we use today in Section 101. And there is a reason for why we keep the words the same as we go through centuries. It's because all of these words kind of get defined by the courts. And so when I say inventor discovered any useful art, I now have 200 years of case law that tells me what invented means, what discovered means, what useful means, what art means, right? And so because I have that, then now if I go write a new legislation, I'm not going to change the words, because if I change the words, that tells the court that this is a different concept from the concept that we previously dealt with. So now we have to go and define these terms. Whereas if I use the same word that we've been using since 1790, the court sees it and says, oh yeah, I know what this word means. It means whatever it has meant since 1790. This was just a historical tangent that I took on Section 101, just to show the continuity of the thought process, that really this gatekeeper section has been with us since the very, very first patent acts. We'll discuss some other aspects of the Section 1 of the 1790 Act, because we'll see that other provisions of the patent law that we use today can be found here. So that was kind of the first thing that we see jump out of Section 101, that it's a gatekeeper provision. What's the next one? So we go through it sentence by sentence. On slide 16, whoever invents or discovers any new and useful. This useful is called the utility requirement of Section 101. There's another utility requirement in Section 112. They are different. They have different standards. And so when we patent attorneys talk about the utility requirement, we always have to specify, are we in Section 101 or Section 112? In Section 101, the utility requirement is extremely easy. the invention has to have a use. And this basically is there to get rid of crackpot inventions. So, for example, perpetual motion machines, right? We've had hundreds of applications throughout the life of the U.S. Patent Office for perpetual motion machines. Perpetual motion machine is a machine that once you set it going, it keeps going without any additional energy input. That is scientifically impossible. It runs against the second law of thermodynamics. And so right off the bat, the patent office says, this is not useful. This doesn't comply with the utility requirement. Why? Because a perpetual motion machine can't be used as described. And this is a line from a famous court case, that which cannot be used cannot be useful. I mean, it goes without saying, but this is really the logic of why inventions that are scientifically impossible are not meeting the utility requirement. Of course, someone like Benjamin would say, well, what about something scientific that the science is wrong, but it works? And so we say, oh, if it works, then it satisfies the utility requirement, right? Because if it works, it has a use. And so, yes, the patent laws allow for the scientific principles to be incorrect, because the patent laws worry about one thing and only one thing. Does it work as claimed? That is all. So the next sentence on slide 17, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or improvement thereof. These 5 things, process, machine, manufacture, composition, matter, improvements, these are called statutory subject matters. So when you file a patent application, your invention has to fall within one of these. In my area, this is not an issue at all, right? Because I deal with compounds. Compounds are compositions of matter all the time, or method of synthesizing a compound, or a method of treating a patient. Those are all processes. So in my work, I hardly ever see a Section 101 rejection over this. Where do we see this nowadays? Really nowhere. The thing is that we all have learned that things are one of these 4 things, plus their improvements. And so nobody ever submits a patent application that's not one of these. I once had someone who came to my office, and he basically told me that he found a formula for life. And I'm like, what does that mean? He showed me a piece of paper with a whole bunch of things written with red magic marker on it. And he said, see, this circle is the earth, that thing is, that, and blah, blah, blah. This is the formula for life. And so you don't ever say, get the fuck out of my office, you fucking idiot. You basically say, unfortunately, the invention that you have doesn't fit one of these 4 statutory subject matters, so I can't really do the patent work for you. I never saw a patent application published. So my guess is that he had a tough time going to other patent attorneys and getting somebody to do that for him. Anyway, so those are the statutory subject matters that falls out of this. And then the last thing that falls out of it is you may obtain a patent, therefore. That means you can get one patent for each invention. Well, what's an invention? An invention is a subject matter that's defined by the claims. So if I go ahead and change the wording of the claims so that the scope of one set of claims is different than the scope of another set of claims, meaning that one set of claims covers inventions that the other set of claims doesn't cover, then those are two different inventions because they talk about different things. They talk about one has some other stuff to it that the other one doesn't. So therefore I can get another patent, but I can't get a patent on two sets of, I can get two patents on sets of claims having identical scopes. That is called double patenting. When you're about to get two patents on the same invention, it's called double patenting. That's one of the rejections that we get. So if the scopes are identical, you get statutory double patenting rejection under Section 101. If the scopes are not, we will deal with that when we deal with obviousness, on obviousness type double patenting rejections. So what if we all know how to do these claims? So the subject matter falls into one of these four. Are we now free and clear of Section 101? Is Section 101 now superfluous? No, because the U.S. Supreme Court has gotten in the way. They have created, on slide 19, 3 areas of judicially created exceptions. Judicially created meaning it means that these exceptions are not in the law. Congress did not pass these. These are exceptions that the courts, through common law, have come up with. The courts have said laws of nature, mathematical formulas, and natural products are not patentable. Those do not fall under the statutory subject matters of Section 101. This is a controversial area of law. For those of you who like philosophical weeds of law, this is a great place to go into the weeds and never come up again. I wish I asked Jim to be here, but unfortunately he is having a family tragedy to deal with these days, and coming to Clubhouse and debating the merits of judicially created exceptions to Section 101 is not number one on his priority list. So we may defer that conversation to later, but just know that these are exceptions. So what's a law of nature? So the court says, you cannot patent E equals MC squared, because that's a law of nature. You cannot patent Newton's laws of motions. Those are laws of nature. What are mathematical formulas? Well, they're mathematical formulas. And what are natural products? Well, those are products that you get directly out of nature. So in my area, Section 101 rejections that I get are in the natural products. That what you're doing is basically figuring out either a law of nature or isolating a natural product as part of your pharmaceutical process or product. I'm going to, I know, sorry, I'm running a little long. I'm going to talk about three cases and one event, all happening in the first half of the 1980s. And all of these basically put the US patent practice into overdrive. And this is why the US became a leader in patents and patent law, and concurrent with that, became a huge leader in technology, both biotechnology and high technology. The first case is Diamond v. Chakrabarty. Diamond was the commissioner of the US Patent Office. And so a case that comes out of the patent office, where there's only the inventor involved, there's no other party that's infringing or doing that. In a lawsuit, the other party will be the patent office, as represented by the Undersecretary of Commerce for Intellectual Property. So Diamond was the director of the patent office, and so he gets named as a defendant. Here, his name is first because it's the patent office that's appealing to the Supreme Court. So what did Chakrabarty find? Chakrabarty worked for one of the giant oil companies. He was a molecular biologist, and he came up with a line of bacteria that had genes from 4 or 5 different species of bacteria involved. And what this bacteria would do is they would eat up oil, petroleum oil, and convert it to smaller organic molecules that would get dissolved in the ocean and kind of go away. Solution to pollution is dilution. And so we still use these bacteria. They work really well on oil spills of a certain kind. The patent office said, no, you cannot get a patent office because it's a living thing. It's a natural product, and you can't get a patent on a living thing. And the Supreme Court said, no, everything under the sun made by humans is patentable. Of course, in 1980, the Supreme Court said everything under the sun made by man. But today we shorten that. So basically, this bacterium, having genome of 4 or 5 different bacteria strains, is not found in nature. And so the only reason for its existence is because humans made it. This is therefore a human-made invention and is patent eligible. This case started the biotech revolution in the United States. The second case is Diamond v. Deere. This was, again, same Diamond guy at the patent office. Deere had come up with a rubber curing process that on the fly used the Arrhenius equation to determine the rate of the rubber curing as the temperature of the oven changed, because the oven temperature control was not very good. It would heat up, cool down, heat up, cool down. On average, it had the set temperature, but not at any given moment. So the curing process would speed up, slow down, speed up, slow down. And so the question was, Well, how long should it be in there? We don't know once the oven is operating how the temperature fluctuations occur, so we can automatically stop the process. So Deere had this process to continuously measure the rate of curing process by inputting the current temperature into the Arrhenius equation. It's a thermodynamics equation. We don't need to know exactly what it is. And at the end, when the computer would determine that the conditions for curing based on calculations based on that equation were satisfied, it would open the oven and stop the heating process. So it would basically cool the rubber down. It worked like amazingly well. And so the patent office said, no, you're using a natural law, the Arrhenius equation, in this, and so this is not patentable. The Supreme Court said it is patentable because because you are not patenting the Arrhenius equation. You're not foreclosing the use of that equation to other people. What you're doing is that you're using that equation to do a patentable process. So constantly calculating the time, and then at the end of it, stopping the oven is a patentable process. You're just using the computer at how you're doing that. You're just not saying, I'm going to use the Arrhenius equation. You're saying, so basically the invention is at the end, the oven opens up and the rubber is cooled down and the curing process is terminated. The third case is Hybridtech v. monoclonal antibodies, 1984. I had the fortune of first patent job that I got at the law firm was with the team that represented Hybridtech in this dispute, which eventually were victorious, and so I was trained by those guys. And they also, we knew we were going to lose at the district court level because until the end day of the trial, the judge kept saying monoclonal antibodies, and so it was clear that the judge didn't understand the lick of the science that was going on. But then this case goes to the Federal Circuit, the Court of Appeals for the Federal Circuit, and their Judge Giles Rich. If you know any patent law judges, Giles Rich is the one to know. He's long dead. I remember his retirement. I was a patent lawyer by the time. Judge Rich wrote the Patent Acts of 1952. So all the code sections that I will be teaching you, those were all at the time he was a lawyer in private practice, but then was hired by the Senate Judiciary Committee to draft this legislation, and then was put on the court to adjudicate this very same legislation. And so his decisions carry a lot of weight because he's the guy who wrote the law and now is telling you what the law means. So in Hybridtech, Judge Rich starts out, goes through every single section of patent law, and based on that makes an argument that biotech inventions are patentable, and Hybridtech v. monoclonal antibodies is really the Marbury v. Madison of biotech patent laws. In 1982, prior to 1982, court cases, patent law court cases were appealed to the regional circuit. So like if you were California, you had a patent case, it would get appealed to the Ninth Circuit. If you're in New York, to the Second Circuit, etc. And that created a lot of disparity between the circuits. The patent law was getting developed differently in different circuits. And the US Supreme Court wasn't always willing to get in and resolve the dispute between the circuits and unify the law across the nation. So that gave rise to what we call forum shopping, meaning that the plaintiff looks around to see which area of the country has the laws that are useful to it and files the lawsuit there. Forum shopping is legal, but is hated by everyone, except for the people who at the moment are doing it. If somebody else did it to them, they would also start hating forum shopping. So Congress, based on a lot of cajoling by Judge Rich. At the time, he was the judge of Court of Customs and Patent Appeals, CCPA. He forced Congress to create this federal circuit. So they created another regional circuit called the Federal Circuit. All patent cases get appealed to the federal circuit. So for 99.9% of cases, the decision of the federal circuit is the final decision because the Supreme Court hardly ever picks up a patent case. The formation of federal circuit in 1982 again streamlined patent law and allowed patent law to move forward. Okay, that's what I wanted to talk about today. Sorry I went a lot longer than I had anticipated. Next time, I'm going to rope Jim to come here because I want to talk about the cases of Mayo and Alice. Those are the latest meaning, 10, 12 years ago, pronouncements by the U.S. Supreme Court on Section 101, and they are a thorn in the side of every single patent attorney. No patent attorney likes these cases, but we have to live with them. And so we'll kind of discuss what those are in Section 101 and then move on to the interesting part of patent law, novelty. How do you tell if an invention is new? Okay, thank you for listening, and let's go to Q&A.
Thank you, Sam. Great room as usual. Am I the only one who finds this idea that you can't patent formulas stupid, just plain stupid? Is there a case to be made there? Can you make the best case for this idea, in other words?
Yes. And that's the controversy in Section 101, which, by the way, is an academic controversy. You don't see any courts subscribing to this controversy. The controversy is that you don't need those judicial exceptions because Y is equal E equals MC squared not patentable. It's not because it's a natural law. It's because it has been around since the Big Bang. So the universe is prior art against you. E equals MC squared is not new. Why can't you do Arrhenius equation? Because it's been around since the Big Bang. Why can't you do a natural product? because it's been around since that plant with that genetic makeup came about, right? So then, is this a brand new formula? Well, why can't you be able to patent a brand new formula? You can patent a brand new plant, or patent a brand new compound that looks similar to what's found in nature. So why can't you do a formula that's similar to what's found in nature? So, as I said, this is a really sausage making, into the weeds academic argument, but answers your question.
Okay, the only thing that's pushing me into thinking this is completely dumb is because, at least for simple, well, okay, let me rephrase. I believe that, and you may challenge this, but I believe that every machine could be translated into a series of formulas. And every series of formulas can be made into some Turing machine. Now, can it be realized? Can it work in real time? Can it be, but probably not, right? The technical details of translating it into a mechanical actual machine or an electric machine are weird, and maybe you can find counterexamples. However, this is what I have in mind. And if that is the case, then I find it untenable that you're allowed to patent machines as much as you want. Making a new machine is always allowed, but making new math is never allowed, whereas there is this clear translation between the two.
Welcome to my nightmare. That what you're no really what you're talking about is precisely the tension that is in the case of Alice that we're going to talk about the next time, because that is the so that is kind of a formula for a financial activity. They're trying to patent that, and so it's exactly what you say there. In Alice, I can make you a really, really good argument based on novelty why this shouldn't get patented. In fact, I didn't do that. Professor Mark Lemley at Stanford, he's probably right now the giant of IP law in the United States. He made that argument through a series of papers, and the papers were well received by the patent law community, but not by the patent law bench. So we'll talk about all of that next time. That is, your criticism is extremely valid, as far as I'm concerned. And there are those patent lawyers who disagree with me, and they think the way the Supreme Court is doing it now is the correct way. But that's that's philosophy.
Yay! Perfect. More. Where's Ben Tristram? Is he here? He's here. Hi, Ben.
Sam, this was a really great presentation. Kudos.
Thank you.
When it gets down to Shamash's question, does that map well onto the other question about biology, where biology is not patentable, but if it's man-made and has an application? In other words, can you use the phrase as a means to X as a kind of a get out of jail free card here in the case of a formula? Or is that option not available?
No, the legal arguments are exactly the same. In fact, the case of Mayo, when it came up, the Supreme Court granted cert, so they agreed to hear it. But in the meantime, they decided Alice. And so without hearing arguments, the Supreme Court withdrew cert and sent the case back down to the Federal Circuit and said, now decide this based on Alice. And so the Federal Circuit sent it down to the district court and said, gather up evidence and arguments based on Alice, make a decision, and then come up here, see what happens. And then they did that. So Mayo is philosophically based on the arguments made in Alice. Alice was a financial services invention for hedging. It was a financial services thing. The hedging was the other case. This was a financial services that used mathematical formulas. Mayo was a blood test telling you the amount of metabolite for a drug in your blood to see if you need to increase the dose or lower the dose. So they're like from completely different technologies, but the philosophical and legal underpinnings of the decisions are exactly the same. Did that answer your question?
Yeah, several ways. So what I take away is this is very much a matter under review at the moment. Alice seems to be new case law that's quite fresh and singular, and it seems to have a decision. And because you're going to talk about it next time, you're not going to talk about it now. So there's that.
Yeah, usually 10 years is not long enough after a Supreme Court case to see how it's operating. What is its effect? 10 years is because by the time an injury happens, until the case gets to the Supreme Court to figure out did the lower court do a good job or not, that takes more than 10 years. So Alice, we see case law coming up a lot, but they're mainly at the Federal Circuit level. They're mainly cases that are kind of cut and dry. They aren't really controversial. So yes, you're right. Alice hasn't been kicked around enough. Mayo hasn't been kicked around enough for us to know where all the holes are and where the problems are. Hi, Steve. Welcome.
Hey, Sam. Hello, everybody. Good afternoon. Sam, I was going to hang in the audience and just listen because I've only been here for 10 minutes max. But you, of course, I knew you would. You brought up an issue that clearly piques my interest. What you just referenced about 10 years in Supreme Court cases. Now, I know in my wheelhouse when we get like a California Supreme Court case, because my wheelhouse, we never get US Supreme Court, but in California Supreme Court case, when something is decided finally, no appeal, i.e., it takes effect immediately, and we notice results in 12 to 24 months. So I wanted to ask you, when you're referencing your 10-year rule, which you just talked about, um, is that different depending on the type of law, i.e., civil law, criminal law? And also, what other comments do you have where the 10-year law may either be shortened or extended? And I know this is just your humble opinion, but I respect you because you're an expert. Thank you, Sam.
Thanks. Thanks for the nice comments. So there are a lot of ways you can do to fast track a case. You can do forum shopping, go to Northern District of Virginia or Eastern District of Texas. They have what we call rocket dockets. They deal with a case really rapidly. Or you can file, in Southern District of California and just see the case 15 years later. So there are a lot of different things you can do to affect the speed. So let's say this a patent case is filed under normal speeds. So first of all, was this patent examined under Alice provisions? Alice came out in 2012, 2013, thereabouts. Then it goes to the patent office. Patent office reviews it for a couple of years, waits for 2 or 3 federal circuit cases to come out. Then it promulgates examination guidelines based on Alice. Then a patent application is filed, gets examined under Alice. It takes 4 years for that patent to issue. They sue someone. From the time a lawsuit is filed in complicated patent cases until the final adjudication at the district court, say 3.5, 4 years goes by. Then you appeal to the federal circuit. That takes about 8 to 9 months. Federal circuit sends the case back down to the district court. District court has to gather a lot more evidence. That takes another couple of years, goes back up to the federal circuit. Then you ask for en banc hearing. So all of that takes about a couple of years. And then the Supreme Court grants cert. They grant cert this year. They hear the case next year. They issue the opinion the year after that. And so the 10 years I'm talking about is basically from the time the Supreme Court issues its Alice opinion until it has to come back and issue a new opinion on the same thing. And so because these cases go up and down, up and down, up and down so much, that 10 years basically spent in courts. And in the meantime, the federal circuit is issuing opinions. But, if the federal circuit issues the opinion, you get to argue with the patent office that the federal circuit got it wrong. If the Supreme Court issues an opinion, you can't argue with the patent office. So, the arguments get lengthy and complicated, and then the Supreme Court doesn't always take on the first cases that come up. They wait for the lawyers and judges and all that, hash out all the stuff through multiple litigations and appeals courts cases until the issues kind of become clear what the issues are. So that's where the 10 years.
Sorry.
No, I'm done. I'm done.
Thank you. I just wanted to say I misunderstood what you were saying, but thank you for the timeline. I'll just revise what I'm saying in my wheelhouse, that for like a completely new disputed issue, from where the case is first heard and tried, and then if it appeals all the way up to the California Supreme Court, that is not a 6 to 24 month timeline. From the first time the case is tried on the trial judge until appeals, it could go as much as 2 to 5 years, but that's only in my wheelhouse, which of course is California work comp. But Sam, thank you very much. Appreciate it.
Absolutely. On the state side, trials go a lot faster than on the federal side. Federal cases are more complex. I mean, that's the joke. He made a federal case out of it, right? That means he made it really complicated, and there's a reason for that joke. Federal cases are more complex. They require a lot more briefing. They require a lot more discovery and witness interviews, especially patent cases. Those are among the federal cases are the most. I mean, I'm outside of bankruptcy. These are one of the most complicated set of cases that you get. They're really fact intensive, and patent cases have a couple of other procedural requirements in the middle. For example, the Markman hearing, where the judge has to decide what the meaning of the patent of the claim terms are. So all of that adds time on the federal side.
And I'll just close, well, at least I'll land my comments here that if you are a juror in a federal court, you have to dress nicer, i.e., you have to wear a collar and arguably a coat, a sport coat. Whereas in state court, you can come in a T-shirt and jeans as a jury pool. Thanks.
Thank you.
You also get paid more to be a juror in a federal court. I think in state court it's like 30
Yes.
or 30 or $35. In federal court it's 50. Ah.
Other questions?
Well, yeah, maybe Sam, I was gonna ask something like, that there's the four statutory categories. I'm looking at, it's process, machine, manufacture, and composition of matter. So which category possesses the greatest challenges, for like modern AI and biotech, like inventions, would you say, if that's a question?
Yeah, that actually goes on slide 19 under judicial exceptions. That would be mathematical formulas.
Okay, yeah. Slides more. Looking at the YouTube. Okay, and then so like how you advise like clients on like distinguishing between like patent ineligible mental processes, I think it said, and patent eligible like computer implemented methods, maybe.
Yeah, let's if you don't mind, postpone the answer to that question to next week, because that is the subject matter of the Alice case, and so we will be talking at length about that next week. Is that okay if we postpone it?
Oh yeah, of course. Yeah.
Thanks.
I was gonna ask another question. Did someone? Oh, okay. Okay. So what about So your life sciences practices. What do you think the disparity between like biotech patents, because they fare better than software patents, right? In section 101. So based off your life sciences practice, why do you think this disparity exists.
Can you repeat that?
Yeah, biotech patents fare better than software patents in Section 101. From what I
So
heard,
what do you mean by better?
they seem to fare better in court in cases from what I've heard, but maybe that's wrong.
No, that I haven't seen any statistics, but I don't believe that's correct. I think you may feel that way because fewer biotech cases make it to general news, because they were mainly at the small to medium sized company levels when you see those. So no, in biotech, we're all worried about natural products, right? Is the new antibody that you have, is it really a new antibody or not? And the case that decided genes are not patentable, I still have a difficult time with that case in terms of, well, what's anyway. We can talk about that when we get there. That was a huge Section 101 case, and so no, I don't agree that it's Section 101 affects computer inventions more than biotech inventions. It doesn't affect chemical inventions and mechanical inventions as much. That's for certain. But in high tech and biotech, I think they're both as vulnerable.
Okay, yeah, maybe I'm jumping ahead. I was gonna ask stuff if the client brings, an AI system that detects fraud in financial transaction using machine learning or ML. Like, what would be your initial 101 analysis and prosecution?
I need to see what it does, right? So the thing is that the Federal Circuit came up with in its Mayo case with the machine transformation test, which basically says whatever process that you have either has to move a machine to do something or transform something into something else. That is, invention always has to have a physical change associated with it. It can't, if you're just moving data from here to there, that's not an invention. Okay, you take the data out, you manipulate the data in the cybersphere, and then you move it to another location. That is not an invention. That is not patent eligible. How do you make that patent eligible? Is when you move the data from here to there, something happens. So kind of like in Diamond v. Deere. What happened there is when we moved the data from here over there, it opened the oven and cooled down the rubber that was in there. So some transformation, some machine action happen. If you don't have that, then you're screwed. You're patent eligible out the bat. If you have that, we still have to analyze to see, based on other criteria in Section 101 analysis, whether you're still patent eligible or not.
Hey,
Sam, based on what was just asked and answered, I notice that you didn't mention anything about coding. Does whether whether or not the coding is similar, different, or related have any effect on what you just said? Thank you.
The code itself is not patentable. The process that the code implements may be patentable. The flowchart for the code, meaning the process of analysis that the code does, that may be patentable. Maybe. I would have put a lot more positive emphasis on the maybe before Alice. After Alice, not as much, but we can still see some patenting activities in that area, albeit a lot more difficult. So the code itself, no, that's copyrightable or protected by trade secrets, but it's not patentable.
Thank you.
Sure.
what about a diagnostic method? An AI system patent that performs the same, diagnostic function as one you're prosecuting one.
Sorry, say that again.
Like how would your approach differ between prosecuting a diagnostic method patent, versus a corresponding AI system patent, that performs the same diagnostic function?
The main answer is I don't know. And the longer answer is I don't think anybody knows. Because we haven't had the new version of AI inventions going through the patent office to see what kind of claims the patent office thinks are allowable. And then we haven't seen decisions from the Board of Patent Appeals to see how the board internal to the patent office views AI inventions. And we haven't seen anything from the Federal Circuit to see how the courts review AI inventions. So that is an area of law that if I were a 25-year-old attorney starting out, I would throw myself into that and become an expert in it, because that's going to be the future of patent law. The same way that when I started out, I threw myself into combination therapy and formulations for combination therapy and made a career out of that for myself. Because at the time, combination therapies were new. So I don't, as I said, we don't know yet. This is a brand new area of law that we don't know how the courts will decide. I mean, yeah, we do have some court cases, but one or two court cases don't mean anything. They're how do you know they're not outliers? You don't make an opinion from two or three court cases. So Myrna had a question.
Yeah, the question is, can you file a new patent that is iterative of a prior art?
So the real answer is no, right? You can't do that because you cannot recapture prior art. But in some areas, depends on how creative your patent attorney is, to be able to draft the claims so that the claimed invention is patentably distinct from the prior art. And so, but the main answer is no. You cannot recapture prior art. Oh yeah, en banc. I used that term. EN space BANC. It's a French term. So in federal appeals courts, each appeals court has 20, 30 thereabouts judges. But for each case, a 3-judge panel hears the appeal, and the 3 judges for the panel are selected at random. And they issue an opinion. You could then, if you didn't like their opinion, ask for en banc hearing. En banc means that the entire panel of the judges, they sit together. At the federal circuit, because we have 13 judges, in en banc, all of them sit and rehear the case, and then they issue an en banc decision. An en banc decision can overturn a 3-judge panel decision, but a 3-judge panel decision cannot overturn another 3-judge panel decision. In larger circuits, like the 9th Circuit, that has like something like 50 or so judges, en banc is a random selection of 13 of the total judges. So they all don't sit, but a much larger portion of them sit. Well, what if the iterative patent is substantially different from prior art? Then it's not iterative. Then it's an improvement, right? So under Section 101, if it's substantially different from prior art, then it's a new and useful improvement of a process, machine, manufacture, composition of matter. Yeah. So as judges have always said, all inventions are based on prior art. All inventions are basically a manipulation of what is known. So for all inventions, we start with the known universe. We start with the prior art. And so is it fundamentally based on prior art, or is it fundamentally the prior art? The newness under the sun is the new arrangement of things, right? I mean, we don't create matter. We always rearrange matter. I mean, we don't create new atoms and electrons and stuff. That's happened once. Big Bang. And then after that, we just move things around. And so, yeah, nothing new under the sun as far as atoms and electrons are concerned. That's correct. But as far as the arrangement of those atoms and electrons are concerned, no, we come up with new arrangements all the time.
I mean, we've made like heavier elements that don't happen in nature, right? And then they sort of evaporate pretty quickly.
Yeah. Anything above uranium 92 is made by humans. Correct.
Hey Sam, just
Hello,
really
Ben.
quick, you mentioned like a ninth circuit with lots of like 50 judges. 13 of those 50 would be sufficient for en banc opinion. I was just curious. Do they need to have a vote for a particular matter to be decided by this 13 judge panel, like by the whole 50 judges, that they agree to take the matter en banc, or there's a smaller number of judges, if they agree to take up the review of the matter en banc, then any 13 judge would be sufficient. The 13 judge panel would be sufficient for en banc opinion.
That's a good question. The majority of the entirety of the judges have to decide to take the case up en banc, even though the majority of them will not be sitting to hear the case. But the majority of them have to agree that this is a case for which an en banc decision will be useful, because the majority may say, this is too complicated. We need to get directions from the Supreme Court, so they deny the en banc motion. Or they would say, no, this is such a simple case that we don't need to sit en banc. Or they may say, we need to figure out what other panels decide in this area first to basically see who has the best opinion and get the arguments hashed out. So basically, the majority of the circuit judges have to vote to hear it, but then a random panel will hear it.
So as far as you know, is the Ninth Circuit the only circuit where the word en banc is not literal?
No.
Okay.
No. I gave that as an example because the Ninth Circuit is the largest. Actually, I think almost all regional circuits are like that. That is more of the norm for an en banc to be a subset of the judges than the rule. I think the Fifth Circuit and the DC Circuit, those are the two that are small enough that for en banc, the entire panel can sit.
Thanks for that. I just want to go back to the AI patent drafting that you were talking about. You're saying that if you're 25 years old, patent attorney, you may want to focus on that aspect of the practice. I was just curious. AI so far, as I recall, AI cannot be an inventor, meaning inventor has to be like a human. So I was just curious, how does that impact in terms of the conception plus reduction to practice thing? Meaning that if the AI came up with the concept of a combination of formulation, and then somehow the robotics got involved in reducing the invention to a practical formulation. So meaning theoretically humans may not literally be involved in the steps of mixing up the chemical, even the conceiving its ABCDE combination. In that case, do you think there will be a problem in terms of you can certainly draft a patent application on that AI creating invention, but is that going to be patentable under the current law? And if not, what are your thoughts on getting around that?
So this is a kind of a live question. in the sense that it is being debated, but we don't have an answer. And we don't have an answer. It is really debated in law reviews, law review articles, and among the academics, because it's a very, very interesting question. And it's a very fundamental question. But as far as I know, this issue hasn't come up yet. That is, we haven't had a patent application go through the patent office where there is no there's no human inventor for us to see how the patent office deals with that issue, and B, once the patent office makes a decision, how the courts will deal with that issue. From a practicing attorney, I don't really opine on these issues unless you give me a week to go do research and pay my hourly rate, then I will have an opinion. But off the bat like this, I don't have an opinion, mostly because whatever I say is going to be wrong. It doesn't matter what I say. It's going to be wrong because this is not the area where I practice in. This is not the area where I read the law review articles. This is not, the area that I talk to other attorneys in. So I don't know what they are doing to claim these inventions. I don't know that.
Here's a novel idea. If said information is pulled from private data source that's not public, then technically it can be defensible.
So Sam, there's an analogous scenario in the copyright field where you can certainly ask a AI algorithm to come up with, say, a painting or a video, if you will. And humans are actually prompting the AI to do it. But the final decision of making the painting green, striped, and yellow, that did not come from actually the human person. That came from the algorithm. So that's a sort of a very awkward situation where if you require author to be physically involved in the copyright in terms of standards, it has to be expression. It's not just the concept or the prompt, as I understand it. Then the machine actually did it, or the AI did it. But at the same time, I don't think we're allowing AI to be an author based on the I guess the most recent proposal from the Copyright Office, which sort of got her fired, I guess, the copyright Registrar Copyright Office. So in that scenario, I think it's possible to have a situation where AI did generate a nice painting, a Picasso or a Monet, but it's hard to say that the human owner of the AI or the programmer of the AI had a part in generating the final output of the painting, so that you'll have a situation where there's a great painting, but really no one no one able to claim ownership of copyright to it, intellectual property to it. And of course, the downstream problem is that can anybody use that for free? Because no one owns the copyright on that particular painting. So I wonder if there's something similar to that in the patent field, where even more likely an AI could generate some great ideas, because patents about methods or compositions, that sort of thing, not necessarily the final embodiments of the examples. So certain AI can be pretty good at doing that because of its capability of generating millions of combinations of chemicals. So I wonder if you have thoughts on that.
Can I interject something as well? being a biomaterial scientist and working with nanotechnology, when you're talking about biotechnology, it is possible for AI and biotechnology to merge. In that sense, there could be weaponization or an, as you say, accidental possibility. Anything is probable in the sense, as we know in theoretical physics. But it is hard for an AI to produce something like that unless there's a base for the person itself to give the AI the ability to think on its to have that parameter where they are able to completely create something on their own, and that could happen in the future. We don't know. Our technology is booming so quickly. I remember when we first started with nanotechnology in the dental lab, and now, nanotechnology is everywhere. So this can happen. There are patents. It's very important for us to protect patents. But the thing is, when we're talking about intellectual property, and I'm sure, all lawyers know this, property, you have to understand it has to belong to a specific individual, and right now, AI is not considered an individual, so they're not responsible. That is a very scary predicament in the future, and that is a question that we have to deal with, and that's why, I've decided to go into AI law, because that is an area that is not that not most people are not talking about. I agree with Sam. It is an area that we need to talk more about. But how do you predict something that's not that you don't ourselves foresee because you have never thought of that idea because it hasn't come up yet. So that is something we have to deal with.
Well, Sam might be busy, but until he,
If I could have 2 minutes, I'll then answer.
I'm sorry, Sam, you broke up. What were you saying?
Sorry, I took a bio break. Let me get set back up.
See, that's the problem. If you were AI, Sam, you wouldn't need to do that. You would just do a AI virtual break. It sucks to be human, right?
Sometimes
I
that's
were,
true.
if I were virtual, I wouldn't be as cool as I am now. Anyway, so there are many ways you can answer your question. I answer your question from a legal point of view. The patent laws require inventorship, and the inventor is a natural person. In copyright law, we have copyright protection subsists. Because I'm not a major copyright lawyer, I have to read it to get it right. Copyright protection subsists in accordance with this title in original works of authorship fixed in any tangible medium of expression. So now the question is authorship. Does author have to be a human being? And there is a case law that says an author doesn't have to be a human being, because we have had computer generated images in the past. Those were deemed to be authored by the computer, and so the point was that it was an original work. It did have creativity. I mean, when we get to the copyright section of this series, we will talk about what does it mean to be an original work? What does it mean to be fixed in any tangible medium of expression? But because the statute is written that way, I think there's less of an issue for granting a copyright to an AI-generated copyrightable work as opposed to granting a patent to an AI-generated patentable work. Did that answer your question?
Sam, I have a quick question then. That's in the case of art, but in the case of nanotechnology or military function, for instance, I would think that there would be more parameters. Is that correct?
Yeah. So in those areas, those are patentable activities, not copyrightable activities. So yeah, in those areas, the way court decisions stand today, an inventor has to be a human, but an author doesn't have to be a human. I don't know what tomorrow will bring.
That's very interesting.
Does that mean that AI could be granted copyright of a particular painting it generates, or a poem, or an article, or a book, that it can be considered owner of a copy?
Potentially, yes, but the owner would not be the AI because that is for certain work for hire, and so the owner will own the copyright, not the AI.
Oh, so work for hire, meaning there's almost a presumptive contract between the AI and its owner. Somehow there's a party A and party B, and then whatever the AI authored, it would be owned by the human programmer or something. Like, even though there's no actual contract, I believe, between the AI entity and the human owner, but the Copyright Office would read that into the scenario. That would be very interesting, because that would bring us to another topic, which is whether AI can be considered a human, meaning can AI be sentient? At least so far, I think no one would want to believe that we want to grant consciousness to AI entity. But if a contract is read into a agency relationship between the AI author and a human person, then you would almost have to assume that AI is some sort of an entity that's recognized in the court of law.
That
Well,
actually is happening right now. My son works with NASA, and I did meet a humanoid, and they do think on their own. And it's interesting, they can communicate with other devices in the room. Very interesting, by the way.
so my question in that case would be, do we then have to revive antebellum laws to define the relationship between the owner of the AI and the AI? Would slavery laws then determine the ownership rights of AI as opposed to the master? Right. That that's going to be, to me, a fascinating conversation. That is, now this AI entity, does it have to have kind of civil freedoms that we expect of humans, or can we own them? Can you own an AI?
Well, to be frank, Sam, if I can even be a bit more sci-fi, it's one thing to say whether we can own AI, assuming sometime down the road AI is granted some sort of consciousness or a human sort of some value that's equivalent to human beings in our society on Earth, I'm thinking something could be even worse. Worse as in worse for human beings. I remember all these famous AI people, Sam Altman, Elon Musk, they're saying, oh, AI is so intelligent. They are smarter than humans. Well, if we extrapolate based on that, could it be in a near future, near as in, I don't know, couple hundred years later, maybe not even that long, then we might be owned by AI if they're that much more intelligent and smarter than humans. That's a fascinating image of the world.
Ben, I was just reading today the article about the first person that received the implant that Elon has invented. And studying neuroscience, intelligence, they don't really have a specific area in the brain that covers intelligence. But it is very interesting that, it is used for medical reasons. I'm sorry, I'm getting a call, but for medical reasons. And it would be great to have, a person moving and everything like that, but weaponization and basically, like they said in Jurassic Park, just because we could, they never stopped to think if we should. And I think that's a question we need to ask ourselves: is should we go to that level? And that's where the lawyers are going to be key in implementing that. That's the future. We need to be prepared.
So I definitely get what you're saying in terms of the we could or we should. My concern and worry is so far I'm still a human being. Knock on wood, maybe I'll become an AI in the near future. But I think it could come to a situation where maybe it's not a choice anymore, meaning that right now we can still decide to grant human status to AI or not. As an inventors has to be a live human being versus a robot or AI. But if AI really is this smart, this intelligent, this capable as it's claimed to be, that it can do all the driving, cooking, war, killing, or even emotional counseling, shrink, etc., then maybe we'll get to a point where we may not even have that choice anymore as humans, that will be controlled slash owned by some sort of self-learning, reinforced learning capable AI. And then at that point, that would be a picture where maybe we should all get on the boat to a Mars, not the boat, the ship to Mars, live somewhere else. I mean, that would probably, I should probably write a 1984 on steroids version of that scenario.
I wanted to comment on a couple of things in the chat. Austin, corporations are not humans. Humans are humans. Corporations are persons. A person has a legal definition, a human has a biological definition. And so Abby is correct that corporations have been persons since the founding of the Republic, and in fact, since the Middle Ages. Corporations were considered legal persons as opposed to natural persons. And Citizen United recognized this, reaffirmed it, and then said by virtue of their personhood, they enjoy certain constitutional protections that we didn't think a corporation would have. So, for example, corporations now have, based on Citizens United, they have First Amendment rights. And yes, Abby, you want to litigate the 13th Amendment. I think we're going to get there because the 13th Amendment doesn't specify whether slavery is limited to humans or not. And so I can totally see a Supreme Court in the future expand the definition of slavery in the 13th Amendment or elsewhere in the Constitution and include non-human slaves or non-organic slaves into that, if we still have a constitution.
That's very fascinating, Sam. Thank you for this. Sorry, gentlemen, I have to leave. I have to go to the lab, but I
Good
appreciate
chatting with you.
everything.
Thank you for
Thank you
being
very
here and
much.
your comments.
Thank you.
Yeah, very little case law on the 13th because nobody had slaves after that, and no state was admitted as that. But there is in the area of the treatment of incarcerated individuals that we've had 13th Amendment arguments uh, that the 13th Amendment says, you can't do this except as a punishment for crime. Then you say, no, this has gone beyond the constitutional provision of punishment for crime, and so it violates the 13th Amendment. I've seen those arguments, but not. But as you said, they're few. Okay. Any other questions? Benjamin, you're pretty quiet. I thought when I referenced the Stanford law professor, you were going to say something.
Old, what do they say about digging up old bones?
Being what?
Digging up old bones.
Oh, yeah.
Yeah, I mean, this field is largely with storytelling, isn't it? Just
Is
people
what?
making arguments. It's storytelling. There's nothing objective about law. It's just competitive storytelling.
So,
It's okay. I'm black and I don't bite. Mario. Hey man, listen.
Hey,
I don't want to scare you, bro. Jeez. Mario. And your name?
Benjamin.
I'm not the guy you see on the video. Okay, Benjamin.
Oh, okay.
I do sales door to door, Mr. Benjamin. That's what I'll do. Me and you both know.
Benjamin, what are you doing, man?
I think a door-to-door salesman knocked on his door.
I know.
This is the first. This has never happened before.
Yes. Anyway,
I know. I want to know now. What is the guy selling? I'm invested.
I know. And we all also know that he's black, and Benjamin shouldn't be afraid of him because he's black.
Oh yeah.
Well, I'm not sure what happened there, but maybe another question, Sam, is like some critics argue that the Alice Mail creates like uncertainty, that like stifles investment, and innovation. So like from your work with startup companies, like what evidence do you see like supporting or contradicting this maybe?
The day after Mayo came out, two of my clients folded. because there was no reason to continue. They couldn't get a patent, and if they couldn't get a patent, there was no investment, there was no market, there was no nothing. So the patent bar is not homogeneous. Of course, we have different people with different ideas because we represent different classes of clients, right? Some do huge corporations, some do individual inventors, and anywhere in between. So there wasn't a uniform response to these cases. They're extremely pro large business because it's the large business that, absent a patent, they can protect these inventions using trade secrets. Small companies have a much harder time doing that because they have to discuss all of this stuff with potential partners, investors, deals, this, that. Big guys don't have to do that. So every time you make patenting more difficult, you favor the big corporations. And so we have seen really since the mid 2000s that the U.S. government's attitude towards patents as a whole is hostile. The Bush administration, W. Bush, the son, was really the worst time in the entire history of the U.S. Patent Office and in the court cases that came out. It was horrendous. It got better, then it got worse, and so I lost the train of my thought. Sorry.
Yeah, I just wanted to echo point. I think another aspect that the U.S. for the past 20 years really has reduced its emphasis on patent protection is the PTAB, where patents are so much more likely to be attacked after granted, and by corporations, especially large corporations, when they're challenged in court for patent infringement. So combined with the more stringent criteria on patentability, Section 101, as well as after the patents are granted, the patents are less likely to be upheld when challenged. I think it really has
I lost Ben. I don't know if, yeah.
Sorry for the interruptions, Sam. I had a knock at the door.
No, that's fine. It was just funny. Yeah, so what Ben was alluding to is what I was saying is that the government has become more hostile to patenting. So, for example, the very big piece of legislation that passed in 2010 and went into effect in main portions of it went into effect in 2012 America Invents Act during the Obama years. It was really, at the time, a unique and right now an impossible act of bipartisanship, that both Democrats and Republicans, in an extremely rare moment, came together and passed the America Invents Act. And in my opinion, did huge damage to the American innovative spirit, because again, one of the things, a hallmark of it, was that the United States was always the first to invent jurisdiction. That is, it didn't matter who filed the patent application first; whoever had invented first would get the patent. But under the AIA, the situation went to the first to file system, meaning it doesn't matter who invented it first. Whoever files a patent application first gets the patent. And the old system helped small companies because they come up with the ideas, but it takes them a long time to develop it into something patentable. But they have that protection of the invented first. But patented first, that favors large corporations that have a huge team and a whole bunch of lawyers, and they put together patent applications left and right, and so they're always filing first. I think the AIA, most of it was an abomination. But then again, I tend to work with startups, and so I tend to view the law not through the lens of large corporations, but through the lens of startups. And startups and large corporations are always at odds with each other. They defend different sets of laws. What works for one is anathema to the other.
Sam, you there?
I'm talking with my mic off.
Yes, sir.
Yeah. So I was going to say, there's a comment in the chat about CRISPR patents. And I was going to say, I don't know much about that. Chinga knows because he works in that technology and he worries about the CRISPR IP. And so he knows what's going on. Unfortunately, I don't. Okay, if there are no more questions or comments, then I will bid you farewell. There's no chemistry room again this week. I have a prior engagement at that afternoon, so I can't do the room. But we'll come back chemistry on Thursdays with a different format. We're gonna do kind of the way John does it, bites of, and kind of maybe, I don't know. Dave and I my friend Dave Coons, we're trying to figure out a format to somehow combine chemistry and pharma patents into that conversation. Talk about the science of it, and then the business of it, and then the patent of it, to see what happens. So look for us 2 weeks from now. Look for the IP room again next week. We're again going to talk about Alice and Mayo next week. And if we have time, start the conversation on section 102, but probably not. Okay, thank you all very much for being here. Shamash, do you have any announcements?
None of my own, no. I'm preparing something different than what we did before. So when we come back, the philosophy will resume, but we will also prepare some different room that has to do with, well, something close to what you're doing here, something that has to do with law, etc. So the environment, carbon, all of that stuff. So if you're interested, that's what I'm working on. But this is let's say a couple of months in the future.
Very good. Yeah, I'm also, in case anybody else is interested, I'm working on a pharma series that basically where does drug development start, and what processes does it go through until you get your FDA approval? What are the different stages of drug development? So I'm working in that. I'm trying to keep it within under 4 sessions, so people don't lose the thread of that. I prepared one all in one session, but it was like I myself got lost. So it has to be broken down into other ones. And Friday, John has his Biophysics room at 9:30.
This one will be festive because this one will be the 100th Biophysics.
Yes.
And he's been making a big deal out of it for a while. So I don't know what he's prepared, but that's something.
Yeah, we're all looking forward to that. All right. Have a great afternoon, everyone, and beautiful life. And I'm going to leave you with The Prophet. That's the name of the song. Artist is Gary Moore. It's an instrumental. The name of the album is Back to the Blues. The room will end at the end of the song. Enjoy it.